Morning, Your Honors. Jason Caruso on behalf of plaintiffs and appellants Bradley Englebrick and Roxanne Hernandez. I just wanted to anchor the court primarily on what this case is really about. Fundamentally, this case is about a defective gas cylinder that almost killed my clients years ago. What this case, however, turned into at the district court and all throughout discovery proceedings was nothing more than an inquisition into my clients' personal lives as to the most embarrassing aspects of their sexual practices.
Well, except for, I have to say, I've been a judge for a long time, and I was a trial attorney, I was a trial judge, all of those. This record of lying is pretty incredible here. So, I mean, that is not the usual lying that you see in a case. I mean, I think I sort of have felt as judges, I probably hear perjury every day because people say mutually exclusive things, or when I was a trial judge. But this it went on for a really long time. And it's pretty incredible. And the meth use is certainly relevant to the device.
Well, and I'd like to address that, Your Honor.
I mean, it's tragic what happened to your clients, but if your clients were in fact, using meth, but there certainly is a lot of evidence before the district judge when he finally dismisses the case that your client may have been using it for, to smoke meth out of it, left it burning for hours at a time. I mean, that they smoked meth every day, that they'd been doing it for years, and there was lots of evidence to that effect, and that they had told their lawyer. Would that be you?
That would be my firm, Your Honor, not me personally.
All right. Well, sometime earlier, and then still continued, and they were in the middle of the trial when it finally got dismissed, right?
Right. That's right, Your Honor. 2 weeks into trial.
How much was left to go, by the way, just out of curiosity?
At least another 2 weeks regarding the defendant's case and the close of plaintiffs. Regarding the materiality issue, the issue of their drug use fundamentally had no materiality to these proceedings, and the court essentially found that. In June 2013, the court entered an order denying an application of motion on behalf of Worthington, saying, despite my discrediting and disregarding the plaintiff's testimony, the plaintiffs have presented substantial evidence of a defect in the cylinder. Now, core to this case is due process, and in light of the fact... Are you saying that the judge could have disbelieved all of that and still have found in your favor? Precisely, Your Honor, and the court intimated that in its order.
And this was a non-juried trial?
It was, to the bench, Your Honor.
I'm sorry, what was this evidence?
The evidence was days of expert testimony by our expert metallurgist, Dr. Ramesh Kaur, who opined that phosphorus used in the construction of the cylinder essentially leaches into the steel body and causes it to be brittle. The steel, under normal circumstances, should be able to bend and absorb energy, and which is what makes steel so strong. These cylinders were made very, very weak.
But was it ever intended to be used as a meth pipe?
Very, very interesting question, Your Honor. An employee of Worthington's said that it was foreseen by him that persons would use cylinders like this even for the act of using it to use drugs. This was actually a foreseen issue by Worthington, not simply a foreseeable one. And I don't want to take the court's time with the idea of superseding cause and all of that, because I think the issue really is proportionality and materiality. That if the court can look at all the evidence before it and say, yes, even setting aside the plaintiff's testimony, I still find substantial evidence. The court has indicated that it can sever apart those issues and still render a verdict based on the facts before it.
Okay, so sanctions dismissal is the highest sanction.
It is.
But so what sanctions would have, your clients have no money, right? And under this, sanctioning could only be of your clients, right? The sanctions against your law firm are different from the sanctions in the dismissal.
Absolutely, Your Honor. The sanctions against my client, the court had many avenues to proceed, as far as taking an adverse inference against my clients, as far as misuse, to even go that far, to ascribe, I'm just going to say that There's 50-50 liability, based on what I've heard so far, even 75% liability. There were $4 million in medical bills. Even a 25% finding of liability against Worthington would have meant something to my clients and was a proportional and available remedy for the court for what happened below.
Is it suborning? There's something called subornation of perjury, which I'm sure that you've heard of.
Yes,
and I mean, defense attorneys, particularly in the criminal sense, are very familiar with it. And when they know that if their client has told them that what they said is a lie, and they're going to get on the stand and lie, and it seems that there was a certain indication that that could be what's going on, why isn't that just, how do you remedy that?
Well, regarding the suborning of perjury issue, I would dispute that there's any indication, aside from the accusations of Worthington, that our firm did anything to suborn perjury. Far from it.
Whatever happened in camera, we don't know what that is, right? Counsel went in camera about when learning, when he knew that his client was lying about the meth use. And that he was.
I'm sorry, Your Honor.
It
never went in camera.
Never went in camera?
Made the request to go in camera, but ultimately nothing was inquired under camera.
Okay,
the evidentiary hearing happened, and Mr. Englebrick, Ms. Hernandez were examined, and.
But then it was sort of aborted. That Judge Carney seemed to feel like, well, hey, I'm gonna, that his dismissal was going to take care of everything, right?
Exactly.
Because that was just, I've imposed the ultimate, so nothing more can happen.
Yes, Your Honor. It was the district court decision that he had rendered the ultimate sanction, and then no further sanction, either of my firm or my clients, was appropriate.
Do you think that's wrong, and then plus you think that they shouldn't be able to go back and get some sanctions against your firm too, right?
Separate issues, Your Honor. And as to Worthington's appeal, I do believe that is a dead issue. That as to our firm, no bad faith was ever intended. To the contrary, and as the district court found, we worked for months to ensure that nothing but the truth was delivered at the district court level, despite everything that happened before. And we did our best to ensure that only the truth was given.
And eventually it was at the trial.
Eventually it was.
But not necessarily the full truth, right?
I'm sorry, Your Honor?
There's only truth, but there's also full truth. They didn't come out and say, your clients didn't disclose until they were sort of cornered that they were using this for meth, right?
They disclosed everything that they lied about, Your Honor.
Well, did they ever say that they were smoking meth out of this device cylinder?
No.
They just said they were meth users.
They were meth users, and they have continued to maintain, and that has never changed, that they were not using that cylinder to smoke methamphetamine on the day of the incident. And to the contrary, my client would not use MAP gas to do this because, as is set forth further in the proceedings below, MAP gas is not useful for that purpose. Very dirty, burning fuel that wouldn't have made sense to use in that situation anyway.
People do a lot of things that don't make sense. You can't, if you've been in a courtroom for a lot of years.
Understood, Your Honor. Understood.
I mean, he did use it. He did have meth the night before. He admitted that, right?
Yes, in the weekend before.
And he said he was still under the influence, didn't he?
I was present when that comment was made, and my comments about that, not necessarily evidence, but that comment was essentially made in the heat of the moment. Well, I don't know whether I'm under the influence.
Which comment was made in the heat of the moment?
Well, maybe I was under the influence at the time of the
Was
file.
it under the heat of cross-examination, as opposed to the heat of the moment?
No, it was the heat of the moment, Your Honor, and it
Well, was
wasn't
he being
cross-examination.
cross-examined?
Yes.
Okay.
Yes, it was, Your Honor. Given I've just got a slight time left, I would like to address Worthington's appeal. Regarding confidentiality, and I think that this is an important point to make, the state bar, and this is codified in the Business and Professions Code, is that our firm and each of our individual attorneys are required to maintain our clients' confidences at every peril to ourselves. And that to the extent that we are going to do anything on behalf of our client, whether it's withdrawing or disclosing confidences, You have to do it the minimum extent necessary, causing the least prejudice possible. And the fundamental dictate, whether you're looking at the ABA rules, the formal opinions, the State Bar formal opinions, whether it's the most current one, 2015-192, is that you act reasonably. And as the district court found.
It may be the case, but the district court here didn't take up, they thought they were barred from raising the sanctions. So the district court never ruled on this.
No, to the contrary, the court indicated to Worthington that it was never barred from considering a motion for sanctions. It was our position that they were barred, which was never taken up by the court, but Worthington was expressly instructed that we have continuing jurisdiction to hear a motion for sanctions.
So the district court ruled that this was not sanctionable conduct?
Yes, Your Honor, multiple times. The court went so far as to say, do not address this issue to me anymore. Please see Federal Rule of Civil Procedure Rule 11. So.
But they didn't get to ask any questions or get any information about that, right?
They got significant information from our clients and the representations of lawyers from our firm on the record.
Well, I guess the whole thing is your client has no money, all right? So the sanctions would be against you. And and so even if they can get attorney's fees on this case, they're never going to get a dime out of your client. So sanctions, if let's say you should have gotten out of the case a year ago and you continue this and they have to continue, defending the case because of the positions that you take, how will they ever be made whole on that?
They could certainly be made whole by a credit against the judgment against Worthington, possibly reducing it to nothing, possibly reducing it to a negative number.
Well, but you didn't win anything.
Oh, it's our position, we certainly could have. And the district court indicated that there was significant evidence, substantial evidence of a defect in this cylinder, which is the controlling issue.
Well, the dismissal also cost you counsel fees and whatever costs you laid out.
Certainly, but honestly, not even a consideration of ours. Fundamentally, this is about not just vindicating our clients' rights.
I'm talking about in terms of a sanction, an effect, even though not directly. This was costly to you in addition to your clients.
More than that, it's the
because
opprobrium that attaches to
arguably meritorious case, even if, according to the judge, even if you set aside the testimony of your clients, there was an arguably meritorious case.
Right. There is a practical sanction against us, if you will, in that respect, which is the difficult.
When he said it was a meritorious case, was that before he heard what he determined to be, I can't believe anything that your clients say?
It's in the very same paragraph. So on page 10 of our reply brief to Worthington's appeal, we set forth the paragraph in full. And in the same paragraph, the court indicates, don't believe a word that the clients are saying. However, there is substantial evidence of defect in the cylinder, which is why this sanction is so strenuous, so grievous.
Thank you.
Thank you, Your Honors.
Good morning.
Morning.
May it please the court, I'm Kathy Huang, attorney for appellees, the Worthington Industries. Since the court has allotted 15 minutes per side, I would like permission to split the 15 minutes with my co-counsel, Mr. Ergo, and I would like to take 7 minutes to address responding to plaintiff's appeal from the dismissal order.
That's fine.
Thank you. In deciding plaintiff's appeal from dismissal order, this court only needs to answer one question. Did the district court abuse its discretion by dismissing plaintiff's case when it found that plaintiffs repeatedly, willfully lied under oath about facts material and central to the pivotal issue in this case? How did the fire happen in plaintiff's bedroom 6 a.m. in the morning on a Monday morning, such that the district court finds that it is now impossible to believe anything plaintiffs have to say about how the accident happened?
Well, can I tell you something that bothers me about this that relates to the fact that this was a non-jury trial? The judge was free to disregard completely the testimony of the plaintiffs, possibly even believe the opposite of what they said, assuming that there was at least some other evidence. It just seems to me to be strange when the judge recognizes that even if you set aside the plaintiff's testimony, there's a meritorious case. And these people have suffered huge injuries, and essentially a meritorious case is being dismissed by a judge who could have decided against them on the merits if he wanted to, and he's sort of avoiding that merits decision in which he could have found for your client, and is imposing what seems to me to be a fairly harsh sanction. It may all be within his discretion. I'm just telling you what bothers me and to give you a chance to respond.
Okay. I would like to say that in the Ninth Circuit is well-founded, and Ninth Circuit addressed that very issue in Valley Engineers and Anheuser-Busch, that in a situation when the court finds that cannot believe anything they say and that there's no assurance a trial can be had on the true facts, then a dismissal is warranted. And it is not enough to simply strike plaintiff's testimony, even though the judge is the only trier of fact here, because without plaintiff's testimony as to how the accident happened, how do we know that how they were using the product, whether they were using the product in an intended manner, in a reasonably foreseeable way?
What was your theory at the time of the incident of what caused the fire? What's your theory?
Based on the evidence that Worthington had to painstakingly piece together, the evidence is compelling that at or near the time of the accident, plaintiffs, being hardcore meth addicts, succumbing to their addiction, were using the torch and cylinder to smoke meth. And I'd like to just highlight some of that compelling evidence to show that Worthington's defense...
Let's say that's true, but so what? So what?
The so what...
The question, I think, Judge Callahan asked is, how did the fire start? You can use it to smoke meth. What's your theory about how the fire started?
We believe that plaintiffs, under the influence of meth, subjected the torch and cylinder to excessive force, therefore causing this brand new steel cylinder to fracture, and in fact the metal even bent by more than 14 degrees. And this is a concession from their own expert metallurgist. And according to plaintiffs, they brought in this brand new cylinder into their bedroom at 6 a.m.
I missed the details, or maybe you didn't state them. You say excessive force. What does that mean? They banged it, or what kind of force? What are we talking about? How did it happen?
Your Honor.
In plain English.
Okay, Your Honor, because we don't have the true facts of how the accident happened, and because plaintiffs are the only two eyewitnesses to the accident, we don't know exactly how they subjected the cylinder to excessive force. What we do have is basic scientific evidence.
The question was,
yes.
What is your theory about how it happened? Okay, that's not a question about facts. That's not a question, we're not asking you to be clairvoyant. We're just saying, what was your theory? What was your client's theory about what happened? How did the cylinder get damaged?
Our theory is that, based on scientific evidence, meth has the effect of causing people to be aggravated.
Super strong? They can bend metal?
Super strong, aggravated, overreact, and because they were under the influence, they subjected the cylinder to excessive force, whether it's because the meth vapor burned them, he was angry, threw it against the wall, knocked it against his computer desk. Some action he took subjected this cylinder to force, causing it to fail.
Well, you could have asked the defendants whether they did that. If they denied it, the judge was perfectly free to say, I believe the opposite is so. What bothers me is that, and what is an otherwise meritorious case in which he was trying non-jury, in which he could have decided it in your favor based on the disbelief of the plaintiffs, he nevertheless chose to terminate it and dismiss it without deciding it. That's what bothers me. It may still not be an abuse of discretion. I'm just telling you that's what bothers me.
In Your Honor, I'd like to just touch upon the allegation of product defect. Worthington sold more than 21 million of these cylinders. Our incident rate was near zero. It was at 0.00007%. By all accounts, this was a very durable product. The U.S. Consumer Product Safety Commission even conducted its own testing of the product, dropping it from height as 6 feet and 10 feet, and the cylinder stayed intact. Gas was still in the cylinder.
Well, that seems to me to operate against your theory. So if they would have flung it to the ground, let's say, it shouldn't have exploded. And they had their own expert testimony who talked about the defect in the design and manufacture of it.
Correct. Earlier you asked about at what stage of the trial was this case terminated, and it was before the defense had the ability to put on any evidence. So the fact that there's this determination that this case is meritorious, that's incorrect. That was never found.
Well, the reason it wasn't concluded was because you wanted it to end prematurely.
Because they decided to wait until 2 weeks into trial to admit that they had committed perjury from the beginning of the case, a case that spanned 4 years.
And how did that admission for the moment, assuming the judge disbelieved it, how would it have adversely affected your defense that you were going to put in? For example, how strong this pipe was and what degree of trauma it could sustain.
May I have the question again?
Yeah, how did it adversely affect your defense? In other words, they admit they lied. So how did it adversely affect the defense you were going to put in? Was, I assume, scientific testimony to support your position?
That's correct,
Right.
Your Honor.
So how did their self-confessed perjury by the time you start the defense case, how would it have prejudiced your defense, particularly if the judge disbelieved them?
How would it have prejudiced us going forward?
Your defense that you were going to put in.
Because fundamentally, we have no assurance that they would be telling the truth from that point onward. And in fact, Judge Carney highlighted this in his dismissal order. Why a dismissal is the only possible sanction in this case is because there is no assurance, even going forward from time of trial, that we would have a just outcome based on truthful facts.
He could disbelieve their testimony. There's never any assurance about in a civil case, it's more likely than not. The verdict for a plaintiff could be wrong under that, 50.1 to 49.9.
I submit that Worthington would be prejudiced because we have no assurance that plaintiffs would ever provide a true account of what they were doing in their bedroom that caused the fire to happen, that caused this product to fail. And without those true facts, how could we possibly have any assurance that a just outcome
But you
can
never
be
have
had?
assurances. Witnesses say what they say, and then your job is to refute that. I mean, since when is having an assurance that witnesses are telling the truth a sine qua non of going forward with the case? If that were the case, we'd never have any trials at all. I mean, have you ever been in a trial where you've been absolutely assured that every witness has told the absolute truth? I don't know. I've seen my share of trials, and I don't think I've seen any of those. It's usually a bunch of ambiguities, equivocations, people making U-turns, people misspeaking. That's my experience with trials. Maybe you live in a different world.
Your Honor, you're absolutely right. I think at every trial, there are witnesses that make embellishments that maybe misremember details. But this case...
Have you ever been in a trial where witnesses have told outright lies? All the witnesses on the other side always tell outright lies, right? This is the way trials are. And your job is to put on evidence and make them eat their words. And this is why we have cross-examination. But, I still haven't gotten an answer. I haven't heard an answer, at least not a satisfactory answer to Judge Corwin's question. Why isn't it sufficient if the problem is you have doubts, or the judge has doubts about what the plaintiffs say, why isn't it sufficient to say, okay, I will now disbelieve every word that they have said? So, they can go forward, but let me just tell you, I don't believe a thing they say. Now, you could at that point maybe, at the end of their case, move for a, what do you call it? I guess
Directed verdict.
well, I guess it's a directed verdict here, jury, but whatever you call it in a bench trial, you say, we want, since you've now, Your Honor, you've said their testimony doesn't count for anything, we win as a matter of law because they haven't met their burden. So if their testimony is key to their case.
Correct.
But from what I hear opposing counsel say, he says, look, we had experts that said that whatever happened in the bedroom, these cylinders should have been able to withstand whatever force they put on it, even unreasonable force, even slamming around, because sometimes these cylinders, these are the propane, these are cylinders that you, right, aren't they?
They're MAP gas cylinders, and they're typically used for plumbing purposes.
Okay. Plumbing?
Correct.
Yeah, and sometimes plumbers drop things, sometimes sometimes they have big monkey wrenches that fall on the cylinder. So, they're supposed to take some stress, right?
That's right, Your Honor. And in fact, plaintiffs produce a witness who's an experienced plumber who testified that he's dropped multiple cylinders as high as 12 feet and never had cylinders.
So maybe that shows that this was a defective cylinder. This was one that was defective, because it should have been able to take whatever stress two crazed meth heads could do in their bedroom with it. If even a plumber can drop something from 12 feet and it doesn't leak, then maybe the answer is there's really nothing. I mean, never mind whether they're telling the truth or not. Let's assume they are crazed meth heads. What could they do with that cylinder that would cause it to be worse than dropping it for 12 feet? Well, it sounds to me like Judge Carney was just angry at angry at the plaintiffs for lying. I mean, what I'm gathering, found that they were lying, and probably with good justification. And the question we have is the fact that the judge is angry at a party for lying enough to preclude recovery without a finding of non-liability?
Your Honor, we submit that Judge Carney's well-reasoned decision to dismiss the case is not born out of anger. It's born out of well-reasoned and well-balancing of the helical factors.
I don't blame him for being angry. I mean, I don't blame him for being angry. You're sitting there for days and listening. You sort of expect people, if you're going to lie, they're going to do a better job of it. And you expect you to.
Well, you actually, what's unusual about this is you had a Perry Mason moment.
Yeah, we all.
It wasn't just lying, but you had a Perry Mason moment where they confessed on the stand. I don't know whether you remember Perry Mason.
I do not, actually, but I understand the analogy. To answer both of your questions, why is it simply not enough to strike or not believe anything plaintiffs say? It's because, just as you've touched upon, plaintiffs' own expert opinions are premised on their false testimony. So, in fact,
how?
Well, if the opinion is the cylinder must have been defective because, as plaintiff said, if fractured upon being dropped onto carpeted floor in less than 5 feet, then that opinion is necessarily based on false testimony. So, in effect, it is not enough to simply strike their testimony because, as the Ninth Circuit,
so they didn't drop it at 5 feet. I don't quite follow your argument. The argument that these things are normally so strong they could withstand that. This one was defective.
dropping it at 5 feet is plaintiff's incredible story of how the accident happened.
And you think he dropped it for how many feet?
I'm sorry?
How many feet would he have had to have dropped it?
Approximately 5, because he said he was holding it right in front of him, and I believe Mr. Englebrick is approximately 5 feet 10.
Okay, given the size of the room, the height of the room, how far could he have dropped it? Let's say he had sort of flung it up. How far could it have? Most rooms are something less than 12 feet, because slab to slab, I believe it's 12 foot, and then you've got your floor and this sort of stand. So you're talking about 10-foot ceiling, maybe. You can't drop it much more than 10 feet in a room, right? There is presumably they don't have concrete on the floor in their bedroom. Anyway, you've eaten into the time. We have eaten into the time of your co-counsel.
I am.
Who's
So
sitting there wringing his hands, but we'll give you some time. We'll give him some time.
I would like to just quickly conclude that a district court's dismissal order.
You've already taken all his time and more.
Okay. Thank you.
Morning, Your Honors, and may it please the Court, Richard Ergo for Appellants Worthington and Worthington Industries, on appearing as for the sanctions motion.
How much blood do you want here?
We want our day in court. Judge Carney said at the evidentiary hearing, what's relevant is what did counsel know and when did they know it? And then I'll make findings as to when this should have been disclosed.
That's a Watergate moment.
Right. We never got our day in court on that. What Judge Carney did was rule on the motion to dismiss. No mention at all whatsoever the sanctions motion.
So let's say you had gotten your day. So what would you have proffered?
Excuse me?
Let's say you had gotten your day. What would you have shown?
I don't know what we would have shown. We would have shown at some point in time before the trial, plaintiff's counsel was aware that their clients had perjured themselves.
And he tried to prevent them from doing it.
Well, the testimony is that client...
And that's by inference, because you can't, on your view, you can't believe what the clients say about when they told the lawyer.
Well, that's all we have. We don't have testimony from counsel as to when they learned it.
They're not credible witnesses.
But we know they learned it before the trial began, and even if they disclosed it right before trial began, we could have absolved with 2 weeks of trial, and we could have gone directly to the evidentiary hearing and found out that their testimony, their false testimony, went to the core of the accident, that they didn't just merely drop this from 5 feet, that the force required to fracture the cylinder would have been taking the cylinder and slamming it down on the ground with all their might.
But you said you could drop it from 60 feet and it wouldn't
From 6 feet? No.
60, I thought
from
if
6
I
feet.
heard your co-counsel correctly about what the expert said, you could be dropped, or one agency tested it, and you could be dropped from 60 feet without
From 6 to 10 feet was CPSC's
Was it-
findings. We even stipulate, we proposed that, let's have a separate trial. If you really, all you did was drop this from 4 feet, then we're liable. But they didn't agree to that. But the force, this cylinder bent 14 degrees. That doesn't happen from a drop from 4 feet. That happens when someone taking a torch and cylinder and slamming it against a solid object with all their might. That's how this accident happened. That's our theory of how this accident happened. And we would have gotten an evidentiary hearing before the trial ever started, and the court would have found out then that there wasn't a thing he could believe about how this
So
incident
you
happened.
would have gotten what kind of evidentiary hearing?
We would have completed the evidentiary hearing that we started. We had the evidentiary hearing as to plaintiff's perjury.
I'm sorry. You said if we had found this out before trial, we could have dispensed with a trial and had an evidentiary hearing. I'm
Yes.
just asking what kind of hearing would that have been?
Well, certainly as to plaintiff's perjury. What did plaintiff's perjury go to here?
No, wait a minute. You're not having a trial. You say instead of having a trial, we've had some other kind of hearing. So why don't you tell me what kind of hearing this would have been?
An evidentiary hearing about all the things that plaintiffs committed perjury about as to how
You
this
don't
accident
just have
happened.
evidentiary hearings in the abstract. You say we have an evidentiary hearing on emotions for X or a preliminary injunction. What would this hearing have been? That would have dispensed with a trial and you've had a hearing instead.
If before trial plaintiff's counsel had disclosed that their clients had committed perjury, the evidentiary hearing would have been as to the scope of their
Committed
perjury.
perjury, what, during discovery, or? When would they have committed perjury?
They committed perjury during discovery, during trial, and during the evidentiary hearing.
But you see, you are not listening to yourself. You said, we wouldn't have had a trial. So this is before trial. So, okay, so put your mind, okay, so you can't have a hearing on whether they lied at trial when you have presupposed the absence of a trial.
Absolutely. We brought a
You say absolutely, but you just said trial, you know.
Well,
So
you
what,
asked
what-
me.
I'm asking you a question. I want you to listen to the question, answer it, not just spew words at me. Okay? You say you would not have had a trial. You would have had a hearing. Tell me how this would come about and what the hearing would have been involved.
After plaintiff's counsel disclosed that his clients had committed perjury, we would have had a hearing before the court as to the scope of that perjury and all aspects of the case the perjury went to.
If he had done this before trial.
Yes. We had brought a motion 2 years before trial to dismiss the case based on perjury. And that was without plaintiff's concessions that they had committed perjury. The perjury here was so drastic that in our...
What
The
was,
trial was already in play when the court was convinced that the perjury had gone to that level, right?
trial had gone 2 weeks.
2
when-
weeks.
when
So how could, my understanding is the hearing that you didn't get was that you wanted to go further at that particular time, but the trial had already started. You're saying you could have avoided a trial. I thought that this came to a head when the plaintiffs were on the stand.
When Bradley Englebrick was called to the stand,
Okay, so the trial was already going, so
Yes.
you couldn't have avoided a trial.
that's when he confessed to committing perjury.
And that's when the scale tipped for the judge.
And that's when the judge, after his testimony concluded, said we are going to suspend the trial and we're going to have an evidentiary hearing as to the scope of the perjury and as to when counsel learned about the perjury and their obligations to disclose it before they did.
So the hearing that you want to reopen, the trial had already started. You're acting like it was before.
Oh, no. Yes, the hearing I want to reopen now is limited as to counsel's role, what they learned and when they learned it.
But that was happening after the trial had already started.
True, yes.
Okay.
and what would have been the instances of perjury if you hadn't had a trial?
What would have been the evidence?
What would have been the instances of perjury?
Without a trial, before trial? Well, Mr. Englebrick said that he didn't think anybody in the house were meth smokers or took meth. He said that there was no meth paraphernalia in his house. And it turned out that the fire department found a meth pipe on his desk. It turned out that meth pipe was a friend of his who also lived in the house, who asked him to hold the meth pipe because his parole officer was going to come visit him later. That's a beginning of the perjury. More perjury, they testified they weren't habitual users. When we obtained the records from the drug treatment center, the disclosure was, in the past 30 days, Ms. Hernandez had taken meth 30 times, 30 days out of the past 30 days, that her preferred method of taking meth was smoking it, that she lived with a person who was a habitual drug or alcohol
So it was
user.
impeachment evidence to prove perjury.
Yes.
But when they admitted it on the stand, that's when it really crystallized.
That's when it crystallized in the court's mind, yes.
I mean, I think everyone's got that. That's the whole purpose of getting ready for trial, is to impeach people. But I would find it very rare that you can bring up I have a whole bunch of good impeachment evidence, Judge, so just dismiss it. Judges don't regularly make findings of perjury prior to trial.
True, but counsel doesn't often disclose that their clients have committed perjury 2 weeks into trial when they could have disclosed that before the trial even began. And I submit that the ethical duties of lawyers, the inherent duty of candor, and the obligations of attorneys as officers of the court is that they need to disclose when a client has committed perjury when they find it out, not years later or months later or even weeks later.
You know, Professor Friedman, Monroe Friedman, takes a somewhat different view of this.
Well, I'm, in reading the Cal,
He passed away recently.
Oh, I'm sorry.
Very sorry, yes.
the California rules and the inherent rules of the duty of candor is that, as quoting from the court in Schaefer, that was quoting the Supreme Court, it's appropriate to remind counsel that you have a continuing obligation to inform the court of any development which may conceivably affect the outcome of litigation, and that the system can provide no harbor for clever devices to divert the search, mislead opposing counsel or the court, or cover up that which is necessary for justice in the end.
That's all true, but let me tell you what troubles me about this is that here you have a lawyer who apparently was trying to get his clients to tell the truth, and he was ultimately successful. And he suffered because, as a result, assuming the dismissal was proper, there was a dismissal of a case that had merit, according to the judge, notwithstanding his client's perjury, and probably cost him a substantial amount of money. And it seems to me that why isn't that enough? He tried to do the right thing.
Well, doing the right thing.
To expose your client when you're a lawyer is a difficult thing, and there are arguments, as Monroe Friedman made fairly compelling arguments, that a lawyer shouldn't even have that obligation because it tends to thwart the ability of the client to tell his own lawyer the truth. But in this case, the lawyer did try to get them to tell the truth, and they ultimately did tell the truth. And it cost him ultimately the sanction. The direct effect of the dismissal was possibly a substantial amount of money in terms of what the judge said was a meritorious case.
The judge never said the case was meritorious. He said there's substantial evidence of a defect.
Well,
and even if there were a defect, that doesn't mean the defect is the cause of the accident, not when someone so substantially abuses its owner, subjects it to massive force, that would be unforeseeable to any reasonable person.
The judge would have to believe that happened, and he could have disbelieved it. We went through this with your co-counsel. I don't want to use it
back to your question. You're right. Counsel apparently attempted to get the client to tell the truth. The client agreed to tell the truth, at least as to some aspects, and consented to that disclosure. Now the question is, under the duties of candor, when does counsel act? Is it fair? Is it comport with the ideals of fair play and a level playing field to hold on to that information and spring it on to counsel and the court 2 weeks into a trial?
Well, spring it on. I'm sure you were happy to have it sprung. I mean, it's one thing if he hadn't disclosed it altogether. That's another story. But
my team and I spent hours and hours and hours preparing for this trial.
Yeah, I understand that, but I'm not sure that all those. I don't want to get into an argument about how you spend time, but you found it seemed to me significant evidence rather quickly, in terms of the meth pipe, in terms of the records from the rehabilitation center. I think he even had a toxicology report. Look, you have a client with a deep pocket, and so you could go on and on, looking for what you already know.
Nevertheless, my team spent time trying to prepare for this trial to prove an issue, assertions that they were contending pre-trial that turned out they were going to concede. I could have focused our team's energies on.
We have to move on.
Thank you, Your Honor. Your Honors.
Thank you, Your Honors. And just briefly, I think you're right, Judge Corman, that there was significant evidence that Worthington could have brought to bear. And as far as the hypothetical situation of pre-trial or disclosure of all these things that Mr. Englebrick had said, let's go to the hypothetical situation where he admits that I happen to be a methamphetamine addict and I used in the weekend before this fire. Can it be seriously believed that Worthington wouldn't have done exactly what it would have done as far as discovery? They would have gone to all of these doctors, gone to all these records, gone to all these friends, because there's no way Worthington is going to say he told us everything. I trust him now. They don't trust him now. It's incredible. It's not worthy of belief. So there's no prejudice. And under that factor, under Halako, I think that factor weighed against dismissing this case. The materiality issue, I think, is important, Kungas versus United States, that if the judge was capable of parsing the falsehoods from the other testimony, that it made sense not to dismiss this case and to do something less than dismissal. And that's especially so given that even under California law, if the conduct is criminal when the product fails, that's not a bar to liability. And as far as this being a surprise at trial, I would just note for the panel that in November 2011, counsel in open court indicated to Worthington and the court itself, we don't dispute they were using methamphetamine in the weekend before the fire, the 2 days before the fire, 15 months before trial. So frankly, Worthington's claims of complete surprise and being bushwhacked, it's an engine with a broken system.
Thank you.
Thank you, Your Honors.
Case just argued will stand submitted.